This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why an appellate court will not change a plea contract and why the concept and theory of invited error makes the sentence imposed on a criminal stand because he can't argue against his own agreement. A guilty plea person can't back out of his plea agreement. Darrell Gentry pled guilty to insurance fraud by presenting to an insurer or another person false or altered statements material to insurance in violation of Idaho Code Section 41-293. Pursuant to a plea agreement in exchange for pleading guilty, additional charges were dismissed in a case entitled the State of Idaho versus Darrell Gentry, decided by the Court of Appeals of Idaho on August 21, 2024. As part of the plea agreement, both parties recommended a sentence of 3 years, with a minimum period of incarceration of 1 year and 3 years of probation. The district court followed the recommendations and imposed a unified sentence of 3 years with a minimum period of incarceration of 1 year, suspended the sentence, and placed Gentry on a term of probation for 3 years. Mindful that he received the sentence that he requested, Gentry appealed, contending his sentence was excessive. Although Gentry received the sentence he asked for, he asserted that the district court abused its discretion by imposing an excessive sentence. The doctrine of invited error applies to stop a party from asserting an error when his or her own conduct induces the commission of the error. One may not complain of errors one has consented to or acquiesced in. The doctrine applies to sentencing decisions as well as rulings made during trial. Therefore, because Gentry received the sentence he requested, he may not complain that the district court abused its discretion in sentencing. Accordingly, the judgment of conviction and sentence was affirmed. In my opinion, insurance criminals are narcissists. They think they can convince anyone of anything. Mr. Gentry was wrong. He agreed to a sentence in exchange for the state dropping some of the other charges they had against him, and he had nothing to complain about, but did so anyway. The court made him stand by his agreement, even if it was more than was appropriate. It was the deal he made, and he was required to serve the 1 year for his felony crime and only a few years of probation. It takes a great deal of gall to try to set aside an agreement made between Gentry, his lawyer, the prosecutor, and the trial judge. He will serve his time, and he might have won, and if he did, he might have found himself convicted of all the charges. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,850 blog postings. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. They're all free. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.